Today is a great day, at least in my opinion, because Meditech got served justice. Meditech just lost a lawsuit in the Supreme Court of Massachusetts to an employee for wrongful termination, and that's what I want to talk about. I feel like the employees at Meditech deserve this. In 2010, a man named Terrence started working at Meditech. He was in a sales position, and some of his money was made from commission, as is pretty typical in sales. But in 2017, the company reshuffled 12 people in that sales department, keeping 9 as sales reps and moving 3 of them to a newly created sales specialist position. Terrence was one of these employees that got put into this sales specialist position, and basically the responsibilities of that job were so different it impacted his ability to do sales and make commission. So they put him on a performance improvement plan, also commonly known as a PIP. It's just when a company is buying time to fire you, or if they keep you, you will never get promoted, you will never get a raise, you have essentially been blacklisted by that company if you get put on a PIP and still work there in the end. In my opinion, if you get put on a PIP, start looking for other jobs. Quick editor's note here, actually all 3 of those sales specialist positions were put on performance improvement plans. However, only Terrence was fired because of a rebuttal letter he wrote explaining why he doesn't think he should be on a performance improvement plan, but we'll get to that. So 2 weeks goes by, Terrence is at this new position, struggle busing, and he writes this letter to the company explaining why his performance has dipped and why he can't make the company that much more money. Let me tell you what Meditech did with that letter. Members of Meditech management met that same day to discuss what he put in his letter to the company. And the president and CEO decided that they should fire him immediately. And just to point out the hypocrisy here, 3 months later, 2 of those other people that got put into the specialist roles were taken off their performance improvement plans. And then one of them that was on a performance improvement plan got told they were put on a performance improvement plan accidentally. So he gets fired, the others just, sorry, our bad, we're bad, sorry, you're not on a PIP, it's a new position, we get, but he got fired. So anyways, he sues them for wrongful termination, and they go to court for it. So let me explain the legalities here. I'm not a lawyer, but I'm going to try to explain it the best I can, at least the best I understand it. So in the state of Massachusetts, it is required by law that companies and employers notify their employees of any change to the employee's personnel record that negatively affects the employee's qualification for employment, promotion, transfer, additional compensation, or the possibility that the employee will be subject to disciplinary action. They have to tell you if they put you on a PIP or if they're writing anything in your records or saying this or that or whatever. They have to let you know within 10 days if they're doing any of that. If the employee disagrees with what the company has wrote down about them in their personnel file and the company does not agree to change it or remove it, then by law, the employee is allowed to submit a rebuttal letter to try and explain what this company has wrote, and those files must both be sealed together. So you can see the company's report, but you can also see the employee's statement as well. In the United States, most of them are at will, meaning they can fire you for any reason at any time. However, there are a few things, at least in the state of Massachusetts, that you cannot be fired for, even though it is at will. But anyways, Terrence, the guy suing Meditech, filed a 1-count complaint in court alleging that Meditech had fired him for submitting the rebuttal to his performance improvement plan. And that's really what this entire lawsuit is all about, but Meditech doesn't understand the law. So when you read their defense, it's just like they're grasping at straws. So he went to court, and Terrence actually lost the first time. He actually lost. They said, it's an at-will state. They're allowed to fire you. It doesn't matter. But Terrence was like, no. They fired me because of what was in this letter. They didn't fire me no matter what. They fired me right after I submitted my defense, and that is illegal. So Terrence submitted an appeal to the Massachusetts Supreme Court, and at the Supreme Court, they decided to recognize it as, yeah, you can still fire him, but you can't fire him because of what he put in that letter. By law, you are required to allow this employee to submit a response to whatever negativity you write about them in their file, and you can't fire them because of what is in that letter or rebuttal, as long as it's not like, threats of physical violence and stuff. We don't know what was in that letter, but the judge does and the court does. And so surely they have decided that you can't fire someone for defending themselves against what the company is writing about them. And that's really what it came down to. So let me explain Meditech's defense on all this. Meditech filed a motion to dismiss the complaint for failure to state a claim on which relief could be granted. Won't somebody think of the CEOs? Nah. Nah, nobody has any sympathy for you, Meditech. Now, I don't know what Terrence actually won from this besides just setting a legal precedent, but Terrence, I hope you won the rest of your life. I hope you never have to deal with this company again. You're just grasping at straws because you got nothing else. And the fact is, you didn't know the law, and you have millions and millions of dollars and all these CEOs and boards, and you should, but you didn't, and you thought that you knew better, and you were wrong. So now I think it's been made abundantly clear just the type of company Meditech is. Meditech will go to court. Meditech will go to Supreme Court to try and defend firing someone because they got salty over what was written in a letter. That is this company. And that's just the facts. They would rather go to Supreme Court than just be like, yeah, we're wrong. They would rather try and defend themselves with bullshit reasons than just own up to it and accept their mistake. The companies will fight you tooth and nail against anything. And this is proof, right? Homie's just like, I got moved into a position that I can't do my job anymore, so obviously I'm making less money for you and me. It's not fair that you put me on a PIP. I don't know what he said. He probably real upset in the letter, but it doesn't matter as long as there's no threats of violence or any of that stuff. You can be upset and just speak straight and blunt and truthfully to your employer, and you cannot be fired for that. You can still be fired after that, but you can't be fired for that. And again, that is setting the precedent here, at least in the state of Massachusetts. So Meditech, you got what you deserve in this case. Clearly you don't value any of your people, and you're willing to just fight over the pettiest stuff. And I hope you learned your lesson, but I don't think you have. And I think everyone that works at Meditech would agree with me that this place is still just spiraling down, and managers and executives and the board aren't listening to anyone. And, you can see that. So on behalf of myself and for the other people at Meditech that currently work there and hate it but can't say anything, I'd like to congratulate Terrence on successfully giving the middle finger to corporate and winning. Congratulations, Terrence. What's funny about this is that the defendant side and other corporations are complaining now, saying, it's taking away at-will employment. You can still fire them, but you have to allow them time to submit the letter to counter whatever it is you're putting in their file, and you cannot fire them for that. You could wait and find some other reason to fire them. You can fire them before that and still allow them to submit the letter, but you cannot fire them because of that letter. And I think that's fair. And I think that's honestly a win for all the workers in Massachusetts. They should be able to counter what their employer says. What your employer says about you isn't necessarily true. I'm sure a lot of you had managers and jobs that hate you and that you also hate and that you would never put as a reference to go get another job. So when your new company is contacting your previous company, they're going to find that stuff. And if they just find the one-sided record of whatever the company wrote about you, that's not fair. You should be able to have a say-so too. And so that's why this law exists. And I think that's reasonable. Personally, companies will try to ruin your entire reputation and blacklist you from the industry just because they don't like you. Just because you wouldn't work overtime or come in on the weekend. Any number of things. They'll find a reason. You're taking away at-will employment. Read the law, moron. That's not what this is about at all. So again, congratulations, Terrence, and congratulations to Meditech for losing. You deserve it. And I hope everyone has a great day today. Meditech employees, maybe cheers your coworker and be like, yeah, congratulations. Even state law recognizes this shithole now. If you enjoyed it, click like, subscribe. If you'd like to see me call out the corporate world some more, since I know you can't, I'm happy to do so. No one's going to hire me again, right? But that's why I got you guys, and you guys support the channel. So I appreciate that, and I will see you in the next one.